As the Court has previously stated, since two unilateral declarations are involved, jurisdiction is conferred upon the Court only to the extent to which the declarations coincide in conferring it. Although the declarations of both parties contain reservations, only one reservation contained in Kenya's declaration is at issue here. The Court must therefore look to Kenya's declaration to determine the extent of the jurisdiction conferred upon it by the parties. To decide whether it has jurisdiction in this case, the Court must evaluate whether the force of the arguments militating in favor of jurisdiction is preponderant and ascertain whether an intention on the part of the parties exists to confer jurisdiction upon it. The Court will begin by considering the interpretation of Kenya's declaration and will then turn to the provisions of Part 15, which, according to Kenya, provide the method of settling these disputes to which the parties have agreed. As the Court has previously stated, all elements in a declaration under Article 36, Paragraph 2 of the Statute, which read together comprise the acceptance by the declarant state of the Court's jurisdiction, are to be interpreted as a unity, applying the same legal principles of interpretation throughout. It will be recalled that Kenya's declaration reflects an intention that all disputes with another state accepting the Court's jurisdiction under Article 36, Paragraph 2 of the Statute, other than those addressed by the reservations, not relevant to the present case, will be subject to a method of dispute settlement either in this court or pursuant to another method to which the parties have agreed. Thus, to give effect to the intent reflected in Kenya's declaration, interpreted as a unity, the Court may come to the conclusion that it lacks jurisdiction only if it is satisfied that there is an agreement between the parties to resort to another method of settling the dispute, that is, the subject matter of Somalia's application. Kenya maintains that its reservation attaches special significance to an agreement to a method of dispute settlement that is lex specialis and lex posterior in relation to the parties' optional clause declarations. The Court notes, however, that there is nothing in the text of Kenya's reservation that makes a distinction between a highly specific agreement, such as a special agreement in respect of a particular dispute, and a general agreement on the pacific settlement of disputes. Moreover, by using the phrase have agreed or shall agree to a binding decision of a third party, e.g. conciliation, however, if no settlement has been reached by recourse to such means, either of those states' parties may submit the dispute to the court or tribunal having jurisdiction under Section 2 of Part 15, unless their agreement to such means of settlement excludes, they do so, that agreed procedure shall apply in lieu of the procedures provided for in Part 15. Section 2 of Part 15 sets out the provisions regarding compulsory procedures entailing binding decisions. If the state party has not made an express choice, then it is deemed to have accepted arbitration in accordance with Annex 7. If the parties to a dispute have not accepted the same procedure, the dispute may be submitted only to arbitration in accordance with Annex 7. Article 288, paragraph 1 provides that, I quote, "A court or tribunal referred to in Article 287 shall have jurisdiction over any dispute concerning the interpretation or